Good morning, everyone. Welcome to our third day. I'm sorry for speaking in Serbian at first. We were just saying hello and setting up some technical things, and you probably understood some of it. So it is my great pleasure and honor to announce today's keynote speaker, Professor Emeritus Sima Avramović. It's a pity that he's not here in person with us, because I'm sure that would be a much more dynamic lecture, but it is very good that we have him here with us online from the Embassy of Serbia in the Vatican, where he managed to squeeze in the lecture between his other diplomatic duties. Professor Avramović has been a long time professor of comparative legal traditions at this faculty. Actually, the subject started as general legal history, and he was the one who changed its name and somewhat its concept to that of comparative legal traditions. Perhaps he'll say something about that too. He was our dean in 2 mandates and did a number of important things, but the thing that is most important for the lecture he'll be giving us today is that he was a long time friend of Professor Alan Watson, and today we shall hear some of that very valuable insight. Professor, the floor is yours.
Thank you, Nina, so much. First of all, I will say that all the event that we have now and all the meeting of the 3 days are mostly a job of our dear Nina Kršljanin, and I'm really very grateful to her for the idea of having Iustoria as an idea, and particularly gathering so much excellent speakers, including a great number of students. This is the way how the students can be attached to the legal history and to the fields which are not very popular in modern times, maybe not so commercial, but very important for intellectual development and for the wider knowledge of all the people, and particularly of the students of law. So good morning from the rainy Rome. I can't stand not repeating it. You cannot imagine what a terrible weather we have outside. But I suppose that it is a bit better situation in Belgrade. Nina, how is the weather?
Pretty good here.
Perfect. Perfect. Okay, this is not basically a lecture. It is, in a sense, a kind of homage to Alan Watson, homage, as French would say. Basically, we are going to speak a bit of Alan Watson and a bit more about legal transplants. But the whole story which connects to those two things is how Alan Watson came to the notion of legal transplants and how this theory founded its place among the scholars all over the world. Let's start with Alan Watson's short biography. He was coming from a small place in Scotland, from a family which could not be defined as a rich one. Not, of course, very poor, but still he didn't have the background as many scholars did. His education in Scotland, in Hamilton, then graduated from Glasgow, and from that moment starts his career. He decided to enroll a PhD course in Oxford. Nota bene, in that time, it was beginning of 50s of the last century. Scottish students usually decided to go to the Scottish universities. They had excellent tradition of universities, particularly of Glasgow and Edinburgh, which were founded on the European foundation. Glasgow was mostly accepting the curricula and the idea of the Paris University. And while Glasgow had connection with Dutch universities and took at the very beginning the Bologna Charter of the higher education. So from the very beginning, you have to know that Scottish legal education as well as Scottish law are a bit different than English. When we say Great Britain, we usually think of Cambridge and Oxford, but until, let's say, 60 years ago, there were nearly no Scottish professor in Oxford and in Cambridge as well. So when Alan Watson decided to enroll his PhD course in Oxford, he was lucky to meet David Daube, famous, let's say, Jewish German professor in the period before the Second World War, and whose family was a great victim in Germany during the Second World War, and who got the chair in Roman law in Oxford. So this is how Alan Watson got in touch with his professor, David Daube. Daube was delighted with Watson's skills, and when he made his PhD, he told him something that he didn't believe. He asked him, "Would you like a position in Oxford?" What I'm talking, it is absolutely a private conversation that I had with Alan, and I'm just transferring to you. It is not written anywhere, so it is, in a way, quite exclusive information that you're going to have. He was absolutely shocked to have a position in Oxford as an assistant, not as a student, for a Scottish young man. It was something that nobody could reject, and that's how Alan started his career in Oxford as assistant of David Daube. And I think that it was one of the most fruitful periods in his formation as a scientist, as a scholar, and particularly as a legal historian, and one who is very devoted to Roman law. I didn't tell that David Daube had a chair in legal history, but mostly he was teaching Roman law in Oxford. So during these periods, Alan made all first investigations, researches, and made a brilliant PhD thesis, as I told you. And he was very popular as an assistant in the beginning of his career in Oxford, but the call of the patria, of his native Scotland, was stronger. And that's why he moved from Oxford to Edinburgh. Nobody believed that someone is going to leave Oxford position for Edinburgh, but Alan was, until the end of his life, a great Scottish nationalist. And he wanted to give his contribution. He was teaching at Glasgow at some time, but most of the period in Edinburgh. Owing to Alan Watson, we had fantastic connections with Edinburgh, great scholar, Peter Burks, Grant MacLeod, and the one from Glasgow, Olivia Robinson. They all have been the guests of our Faculty of Law of the University of Belgrade, and I may say, really great friends and great assets that our students had during their studies to listen to so important authorities. During the course of time, Alan became more and more popular, and then he got an invitation from a bit richer country than Scotland was. It was United States. So firstly, he moved to the University of Pennsylvania in 1980s, and then finally he founded his place by the end of 90s in his beloved Georgia, where he met his wife and got a family. So until the end of his life, he was teaching in Georgia. But he was never forgetting Scotland. He was coming to Edinburgh nearly 2 times a year, teaching from time to time. And since the time we met him, it was in 1990s, he started to come to Belgrade. When he came for the first time, he didn't expect that he will find, as he said, another Scottish spirit in Serbia, particularly in Belgrade. And so he became so attached to our Faculty of Law at the University of Belgrade that he missed maybe every second year to be our guest. Altogether, I think that he was at least 6-7 times professor who was teaching our students and who finally, nearly at the end of his career, but earlier than the end of the career, he invented Alan Watson Foundation, a very important institution which is still alive, mostly, I must say again, thanks to Nina Kirstenin, and Alan Watson is still working. This is still the first hint at Google. If you are searching for Alan Watson, you will immediately see Alan Watson Foundation at the University of Belgrade. So this connection between Alan Watson and the University of Belgrade, and I must say, with his obsession with Serbia, and particularly with Serbian legal history, was something which was, in a sense, included in his researches and in his view on the issue of legal transplants. And now we can come a little bit closer to the main topic, legal transplants and Alan Watson. Alan Watson was a lucky person because he had David Daube as his professor. Roman law was his basic academic legal field. And in the same time, he lived in Scotland, as you may notice, which was not completely common law country. The law which was applied and is applied in Scotland is on a middle way. Now they used to say in theory that Scottish legal system belongs to the mixed legal systems. But some 100 years ago and 80 years ago, Scotland was basically a civil law country. You know the division between civil law and common law. Of course, the home of common law is England, but having different historical experience with England, Scottish lawyers did not accept so willingly English legal tradition, and they were in a close touch, particularly with the Dutch universities, and many of them studied in Holland. So it is considered, Holland is let's say, considered as one of the most important cradle of Scottish legal scholarship. That's how Alan knew from the very beginning, from his studies in Edinburgh, which was completed with David Daube. He knew Roman law like his home, let's say, law, like something that he was growing with, comparing with the Scottish law, which was also based upon Roman law. On the other side, he studied in Oxford, so he had to know common law just in details. And I think that maybe this is the first step that one should remember, that the secret of the success of Alan Watson is tremendous knowledge, both of Roman law and Scottish law, and civil law, and common law means English law predominantly in the time. So this kind of mixture of knowledge that he had enabled him to understand better English institutions, institutions of common law, as well as institutions of Roman law. And this is how he used to think when he meets any new legal systems. When he came to Serbia for the first time, I will never forget, the first question was, you're belonging to the civil law tradition? Of course, as whole Europe, mainly. But it was always his first question, with whom he is speaking, with the common law lawyers or with the civil law lawyers. So when he made the decision to go to the United States, it was a great decision for him because he was basically not only a Scottish nationalist in the positive sense, but he was really very devoted to Scottish law and thinking in the categories of Roman law. On the other side, he moved to United States. He started with his career at University of Pennsylvania, and as I mentioned, and once on the trip from Pennsylvania to Georgia, in the flight, he was speaking with a man who was sitting next to him. He was asking him what he is doing, and he said, "I'm teaching at Georgia. What is your profession?" "Well, I'm trying to make something, the new theory, which I call legal transplants." The guy who was not a lawyer said, "Wow, I'm a rich man. I would like to support your idea," because he was thinking that Alan Watson is speaking about transplantation in the medical sense. So this is something that he told us, making a joke, because at that time he didn't need money because he had a very rich wife. So this is the secret how to not to think about your existential problems. Camilla is really a wonderful woman and a wonderful wife. She was part of Alan's success, and she was also, now she's retired, a professor at the University of Georgia, but in completely other field. So that's how Alan started to deal something which seems impossible before him, to make a connection between Roman law tradition and common law tradition. And the first thing he did was to try to translate Justinian digests in English. This is, I think, one of the most important things that Alan Watson did for the modern legal history and for modern legal civilization. If you just try to find that internet digests of Justinian, the first thing that you will find is Alan Watson. And this is really something, I would say, the first thing that he builds a monument to himself while he was alive. His translation of digest is absolutely, until now, the only one and the best one, because there was one older translation which was completely not successful, easy to understand. It was written by a common law scholar. But the only translation in English of the digest by Alan Watson is the digest which had an author who knew both different legal systems. So thinking about this kind of job he did, he started parallelly with this idea of legal transplants, what he told to a guy in the airplane. And in that time, hello, Milena, nice to meet you. Speaking about legal transplants, he was thinking firstly about this kind of transplants in the field of Roman law tradition. How much Roman law became a basis of different kind of legal systems, and in what sense Roman law is basically in the modern law. So speaking about legal transplants, he told me, yes, of course, it is nothing new. Everybody knows that a transplant of Roman law in different European countries and countries all over the world. But what was his privilege was that he knew perfectly both terminologies in Roman law and in common law. And we were often discussing, I think that Milena is remembering this discussion, how to translate the term loan in English, because they do not have difference that we in Serbian between loan, when you take a loan in order to consume it, take a loan of sugar of your neighbor in order to prepare something, and the loan whose purpose is not to use it, but just not to use it for all the time, like in Zayam, in the sense of the potrošne stvari, in the sense of the things that lose their own substance when they are once used, and the other one when you just use something without exhausting its essence. For example, in Serbian, we usually say wrongly, pozajmi mi knjigu, but it is not right. You should say differently, in the sense that you are posudi mi knjigu. If someone pozajmi ti knjigu to you, that means that you are going to destroy this book and buy him a new one, maybe. So this kind of very, very tiny differences in the institutions in Roman law and the terminology in civil law was a great problem for non-common law scholars. And on the other side, the common law terminology was a very great problem for those who are belonging to the civil law. It was not a problem for Alan. And that's how he made a fantastic idea of legal transplants, speaking that it was okay, legal transplant is a wide word. And he was talking completely rightly that the idea of legal transplants, because it belongs to greater movement in the anthropological studies, movement which was called rather, how do they call, cultural transplants or diffusion of law. Now you have many, many other terms which are speaking about mixture of legal systems. You have now very legitimate term, mixed legal systems, systems with different traditions, but it is all a building which leans upon the foundation of Alan Watson's legal transplants. So when he started to speak about legal transplants, he was very clear, but mostly in his lectures, I didn't find any place where he wrote it very openly and clearly. I think that he simply wanted to make a theory of legal transplants, although it was really something that existed even before him. As he said himself, reception of Roman law is a legal transplant, definitely. But his idea about legal transplants was much more wide, much wider, and I would say a rather anthropological than, strictly speaking, legal. He had this experience with a mixture of legal systems in Scotland, but then he tried to discover other, used to be in many countries along the world, particularly in those countries which switched from one legal system to another. Developing his legal transplants theory, he was very interested in the case of Turkey, because after the First World War and deep changes in the Turkish society, having Kemal Atatürk as a president, having a new secular country, which was done in 19... And the guy who was drafting it used, nobody could believe, Swiss civil code as a model to be transplanted in Turkey. Not a French model of Code Civil, not Austrian famous civil code, not German civil code of 1900, but just Swiss one. And Alan was very interested. He traveled to Turkey. He spent a year in Turkey trying to find why Turkey transplanted Swiss law instead, and Swiss code, instead of other very popular codes which were influencing so many countries in the world. So it was a nice period, as he told to us. I don't know if Milana had the opportunity to listen those stories, that Alan had a girlfriend in Turkey who helped him in researching the issue. And to show the story, he learned Turkish language. At some point, I think that he knew more than 10 languages that he was able to speak. Turkey was one of the languages that he was able to understand, just to find what was the secret of this kind of legal transplant of civil law of Switzerland in an underdeveloped Sharia Turkey. So the secret was very, very bizarre. At the very end of his investigation, he found that the man who was drafting the Turkish civil code, Mahmud Esad Bozkır, studied law in, yes, in Switzerland. So Swiss law was most close to the man to whom Kemal Atatürk gave as a task to make the new law, and he easily said to Atatürk, well, it is the new civil code. It was codified in 1912, I think, and this is the most modern law that we have now, and we'll take it. But basically, as Alan was stating, this man, this let's say founder of the Turkish civil code, Mahmud Esad Bozkır, chose it because he was educated within the ideas of Swiss civil code. And after that story, when he started coming to Serbia, we told him the story about the Serbian civil code of 1844. It is the famous story that Prince Miloš, after the first semi-autonomy or semi-independence that Serbia had after 1830s, wanted not only to have the constitution, but also to have a civil code. And in the beginning, Serbia, in the time of Miloš, didn't have many educated people. And the first one who was in mind to Miloš to help him in this task was the teacher of his son, Mihail, to make some kind of translation of the French civil code, which was very, very popular in that time, just to get acquainted with, to see what is that. The teacher of Prince Michael was Georgios Zachariadis, a Greek, very educated man, but unfortunately not a lawyer. And even worse, he didn't speak French, but German. And he translated French civil code into Serbian from the German translation. That's how this attempt ended in a humorous way. And there are many small stories about that, like that he translates hypothek as apothek and things like that. So those are famous examples from our literature. And then Miloš said, this guy must be drunk or mad when he was translating it, and decided not to accept French model that Georgios Zachariadis was for, as the French legal system was at the time one of the most popular in Europe. Then he gave a task, Miloš gave a task to Jovan Hadžić, who was also great Serbian name in the legal issues. He was in that time in Novi Sad, brought him in Belgrade from Vojvodina, and gave him the same task to draft a code, a civil code for Serbia. But Hadžić was coming from the influence area of Austria, of Austro-Hungarian monarchy. In that time, not that monarchy, just Austrian law. And of course, his model was Austrian civil code. He was so successful, and you all know that Serbian civil code was basically, some would say, translation of the Austrian civil code, but it is really unjust definition, because it is definitely not a translation. Austrian Civil Code had 1,500 articles, Civil Code of Serbia had 950. That means at least Jovan Hadžić had to make some shortages. And he really made a very original piece of codification for Serbia so early as 1844. When Alan Watson has heard for this story, he was so delighted. And he said, this is one of the best examples of my theory of legal transplants. I'm out of a chance. It's just like as the one that you use as a model. And that's how I will try to end with this. Alan used to make three main ways. The most important one was by force. The second was by authority of law. So, make the final idea. So he told ways: forceful, let's say, posed to some country, usually after the conquests, the new rulers in the defeated countries. Authority, when the great legal system, mighty legal, and I am the idea that common law today in Europe, in other parts of the first and more of the seconds, the seconds. But the third is the most favorite and I would say dearest idea, that sometimes the legal comes to the light just due to a pure, like it was in the case of Turkey when the drafter, and that's why he used the Swiss Civil Code as a model, for example, and the Serbian example, where the Serbian Austrian legal system as the basis for its codification. Definitely, he's so complete, and when he counts the reason, he is much more extensive. He would find at least 10 different, but basically he is force, autonomy, and chance. But this last one was the cause for critics to Alan Watson, and that's why Alan Watson is considered as controversial legal scholar during to his legal transplant theory. Nevertheless, his theory is very alive and slightly modified by some other scholars in terms of systems and other new terminology. But basically, is basically a proof that Alan Watson is really a person. Law of the University of Belgrade will remember him for long, long parts of time, and I hope in the history of our school he will stay remembered at least as a doctor honoris causa of the University of Belgrade. Thank you for attention and sorry for the technical difficulties.
Thank you, Professor.
Hoping to see you in Belgrade soon.
Okay, do you have to go right away? Well, maybe due to the connection, it is best since we keep losing you. Sorry for the interruptions, but at least we got to hear the most of it. Now, Professor Avramović is no longer here for us to ask questions to him, but since there are multiple people who are versed in the subject, if anyone has any other comments personal insights, anything they'd like to ask or discuss, the floor is open. Yes, so people online could hear. Yes.
Of course, I will not comment a lot about the legal transplants themselves because I've done that on the first day. So basically, I agree that it still is an important work. I just had a few comments about what was before that. I just realized that actually David Dauber left for the United States before Alan Watson, already in 1970, when he went to Berkeley. So somehow he also followed his master. I thought it was worth mentioning. Something I do only partially agree with Professor Avramović is about the translation of the digest. It is an important piece, absolutely. On this, I agree. And yes, it's a very good thing that Alan Watson edited this. But what I totally disagree on is that it was him who translated the digest, because he didn't do it. If you look at the beginning of the first volume, you will find who were the translators, and all titles have been translated by different persons. And so it is important to have this English translation rather recent, but it still has defects because of that, because it has been translated by so many different persons and without a real supervision of unification of this translation. I mean, it occurred to me, because I didn't know about that. I mean, at first I thought it was an Alan Watson and that was it. But then I published an article in a journal of comparative law. I wrote it in English and I thought, well, I'm safe if I take the Alan Watson translation of the digest, because, I mean, it's not mine, so nobody will complain about my translation. And then in the editorial board, well, the English member complained a lot. He said, well, that translation of the digest is good. That one is barely English. So, because it were different authors, different translators. So this is what I mean when, well, it's not a job completed somehow. I had to make a new translation of that part. I'm not telling the name of the translator of this, but you have really many translators, many different persons. Some you know, some you probably have never heard of. So, so this is also why saying that you have a translation done by someone who knew both common law and civil law, well, that's only partially true, because some translators have no knowledge at all of Roman law. That was my impression, because sometimes it is poor. So never mind. I agree on the fact that it's really important because it makes Roman law accessible in a sufficiently acceptable way in English. But yeah, it has been done a bit quickly. So there has been a second edition which corrected some parts of it. But just to name another problem of this translation is that the Roman law terminology is not unified. So you will have the same word in Latin translated in different ways without any obvious reason. So that's a problem. Now, yeah, about the transplant of the Swiss code in Turkey. Well, most has been said, and I agree on that. I wanted just to add that, of course, there was this author of the Turkish version who studied in Switzerland, and of course, it was the most recent and the most modern, probably, civil code of the time. But it had, if we go back to Alan Watson, another advantage, it's the fact that well, it was easier to go to the small neutral Switzerland to take a code than to go to Germany or France, where that would have created a problem of authority, of course. Now, this transplant created many practical problems. Probably you know about it, but of course, as it has been mentioned by Professor Avramović, going from Sharia to a secular civil code was a problem because they took over also marriage law. So in Istanbul and Ankara, probably they were aware about the new way to marry and that it had to be secular, otherwise it was not valid. But if you were in remote places far away from the big cities, well, people would just go on marrying like before and doing it religiously and not secularly. And this meant that their marriage was not legal and that the children were not legal. So they had no legal children. That was a big problem for practical reasons. So they had to regularly go in the small villages and ask, well, who are your children? Are you married? Oh, and how did you do it? And so did you? Because it was a very big problem also for inheritance law, of course, because there were not valid marriages and successions. By the way, the Turkish civil code has been changed quite thoroughly recently, so it is a bit less Swiss than it used to be. But still, I know that there are still on a yearly basis meetings between the universities of Galatasaray and of Fribourg in Switzerland. So they exchange students every year. So you have 1 year you have Turkish students going to Switzerland, and no, I think it's the same year. It's just, and then vice versa, because they go in the families. Actually, the students go in the families of the others. So that is still living, that old habit after all this time, after more than, no, it is after, well, 1 century. Yeah, and that was it. Sorry for being long.
Thank you very much. I understand about the translation, that that's generally, I presume, a problem of every big team working on a text, and particularly on a translation. I mean, we've had the same problem. Someone mentioned it yesterday, maybe Professor Poloyets, regarding our draft of the Civil Code, because it was also our current, not the 1844 one, but the one that they tried to pass some time ago, because they've made a really big committee with various experts in the field, but they divided the work and nobody did a standardization afterwards. So the terminology, the style of different parts of the code was very different. And then not just for that reason, of course, but that draft was again relegated to, well, we'll see sometime later. And I presume it's even more difficult with the translation. I've been working on using a Serbian medieval source lately that was translated by one person, but it's a huge text into modern Serbian. I don't need the translation myself, but I'm including quotes in the book with the translation to make it more accessible to the general audience. And I saw that the one person made different mistakes of the kind of translating the same term in one way at one point and then half of the book later in a different way. And then if one person can make such mistakes, I presume it's way more difficult with a big team. So that was also just a comment. Any other comments, ideas?
If you allow me to come back on what you just said, because it's really interesting. The size of the team matters, you're right. The more people you have, the more difficult it gets. Certainly if they don't really meet, which they didn't, I'm afraid. But I don't know if you're aware about the translation of the digest in German and in Dutch. The Germans started first, and they're still far from finished. I mean, most of the members of the team who started to work died. So they had to renew the team with new professors. And the Dutch, who started later, with Job Spruit as the main head of it, well, they have been translating much quicker. And though they started after the Germans, the Dutch finished translating everything. I mean, when I mean everything, even the Libri Faudorum. So they went from the Digest Institutes, of course, the Codex and the novels and everything. Of course, the Germans had a look at the Dutch translation, wondering whether it wasn't the Dutch who were right, because at least they finished, whereas the Germans, well, I mean, who did you have? You had Kupisch, who is dead. You had Knüttel, who is dead. But Behrens is still alive, but he left the team. I mean, it's more than alive to to finish that translation, and so the Germans had a look at the Dutch translation, and then sometimes they were quite happy to spot an error. But they said, well, okay, what is the cost of not making that error? It's like 10 years. Is it worth it? So I'm quite agreeing with you that for the sake of efficiency, you might as well go quicker and accept some errors that you can always correct later.
Precisely. Thank you very much. Yes, go on.
So if I just could go to what you said about this lifetime work of translating, what is maybe a chance nowadays that we can use these AI language models to fasten up? Of course, it's not enough to use a model for translating such a legal document, but I am amazed what was the progress between, I don't know, 1 year, 2 years ago and now for translating Latin ancient text into English. Of course, is the easiest one. So maybe it will change in a few years or sooner, so that academic teams can use it in order to speed up. Of course, it won't be very short, but still not a lifetime.
You're very right. I mean, this is total game changer. This is absolutely true. It's fantastic. But yeah, let's see. Now, the fact that you say that it's easier in English, well, as Professor Avramović put it, I mean, English is tricky for Roman legal terminology because you're missing out on a lot of concepts. So
that was off the record, yes. Well, just one thing on the record. So yes, what Professor Gerkens mentioned is a problem. So the problem of the AI probably not being able to select the best translation in context, at least for some time. Perhaps in 20 years it will be able to. If we look at Google Translate now, and back when it started, it used to be very funny. Now it no longer is, at least when translating between large languages. So English and French, wonderful. English and Serbian, not so much. And the more exotic they get, the less of the database they have, and the more they use the bigger languages as a bridge, the more complicated it gets. So I'm really not sure how good it would be for languages such as Latin or, let's say, ancient Greek or something like that. You have some experience in that regard?
I can continue off the record if it doesn't like me. So I remember last year in Rome, Professor Delio Mantovani showed us his experience of using AI. He just wanted to try because the students were using, and he posted Ulpian's text, I don't remember which, but it's irrelevant, into the AI so that it translates it and solved the casus that was inside. So it mistranslated it, absolutely, and so it was unable to solve the casus as well. But then Professor Mantovani pasted his own translation, so the AI was able finally to solve the casus, but it started, the ChatGPT started with, I'm terribly sorry for previously translating it wrong. So it got, actually the algorithm got that it was the same text, but it translated it wrong. But still, in that language, it's very, very, very hard to make any use of the AI for now, at least.
I had the experience, the unpleasant experience recently I was appointed to be the redactor of a translation of a legal book from Russian to Serbian, which was done by a translator with a lot of help of AI, obviously. Okay, some minor mistakes were made because obviously it wasn't Google Translate, it was what was Trados, or what the professional translation software is called. So it's supposed to be a little better because it remembers all your combinations and everything. But first it got lost in cases somewhere where you get, I don't mean legal cases, I mean grammar cases and endings in complicated sentences. So some verbs got connected with the wrong nouns and pronouns. And it also made the problem of, say, in many words, Russian and Serbian are very similar. But while Serbian has had a lot more of Western influence too, so we frequently have the synonyms for the same word where one has a Slavic root, which would be similar to Russian and Bulgarian and maybe sometimes Polish too, and so on. And we have a different one, would say a Latin root or a French root. And then when we're translating the Russian word that has a very similar equivalent in Serbian, for me, it would always be logical to use the very similar Serbian word, because the closer you are to the original, the better. But the software, which probably jumped over English, used the Western variants more often, so I had to correct that. And what was supposed to be just a routine checkup of whether the translator messed up some legal terms turned out to be so much work that I was borderline thinking that just sitting and translating the damn book on my own would be faster. So the AI still has its shortcomings, and they had a stern talk with the translator, but that's a different matter. So any other questions or comments? If not, thanks to Professor Avramović in absentia, and let's have a coffee break.